This is Bloomberg Law.
What does a prosecutor have to prove in order to get a RICO conviction? Tell us why the Solicitor General is sometimes referred to as the 10th Justice.
Interviews with prominent attorneys and Bloomberg legal experts.
That's Jennifer Kay for Bloomberg Law. Joining me is former federal prosecutor Robert Mintz.
And analysis of important legal issues, cases, and headlines.
Is the toughest hurdle for prosecutors proving Trump's intent? Alito took on Congress, saying Congress has no power to regulate the Supreme Court.
Bloomberg Law with June Grasso from Bloomberg Radio.
This is a special edition of Bloomberg Law. I'm Amy Morris in Washington. June Grasso is off today. She'll be back next week. Coming up on the show, fallout from the Supreme Court decision on presidential immunity, plus the justice's decision on restricting social media. And finally, what we did and did not learn from the High Court's latest term. All of that coming up on today's edition of Bloomberg Law. But first, we begin with the most closely watched decision of the term. You know the one. On Monday, the Supreme Court ruled for the first time former presidents are shielded from prosecution for some official acts. The 6-3 decision sent the case back to a district judge, saying the court was wrong to reject former President Trump's immunity arguments out of hand. For more on this ruling and its broad implications, we're joined by Harold Krent, a professor at Chicago-Kent College of Law and author of the book Presidential Powers. And Professor Krent, it is a pleasure. Thanks so much for joining us today.
My pleasure.
Now, we've all had some time to go through this voluminous opinion and the dissents. Just your initial thoughts right off the bat.
Well, the court resisted the temptation to side with either President Trump completely or with the government completely. It tried to take a middle path, but in so doing, it sided much more closely with the President Trump's camp than with the special prosecutor's side. In so doing, they held that a former president can be tried criminally, but only in very rare situations. And I think they, as a practical matter, they erected a high hurdle in this case for the special prosecutor to succeed in bringing the charges arising out of the January 6th insurrection. And they also erected a high hurdle in future cases to enable anyone to try criminally a former president.
Now, they did not specify what those criminal acts would be. They left that for the lower court?
They did, though they did, to the court's benefit, I think they started to create a helpful scaffolding to assist the lower court judge in making the decision. They divided a president's actions into 3 buckets or categories, into core executive actions, they didn't define it entirely, into official actions and unofficial actions. And their quick summary of this is if a criminal action tries to intrude into a core area of a presidential power, that action is immune from criminal prosecution. If criminal prosecution instead stems at an official act of the president, it is very likely to be immune. And if the criminal action focuses on the private conduct of the president, then there is at least a room to say the criminal action can exist. In this case, most of the acts that have been charged against President Trump have been involving President Trump as a candidate for office and therefore in his private capacity. So at first blush, one would think that there is nothing to disturb the prosecution from going forward. But the court then limited its holding in a way that left most people scratching their heads by saying that no official discussions can be part of the case, even against a president acting in his personal capacity. So the best example of that is supposedly, and it's been, I think, confirmed, that President Trump talked to Attorney General Barr and others in the government and was told that there was absolutely no kind of voter fraud. That evidence seems pretty pertinent to deciding whether President Trump had the intent to engage in a conspiracy to defraud the election. But the court has said that that should be barred, so to speak, from the indictment and not presented to the jury in deciding whether or not the president acted in his private capacity in trying to overthrow the election. So it's almost like tying one arm behind the back of the prosecutor in allowing the prosecutor to proceed to try to maintain some semblance of an indictment against ex-President Trump in this case.
Let's take Trump out of it for just one moment. I want to look at the great big picture and way down the road, Professor, if we could. You explained how the different buckets were being presented, the core, the official, the unofficial, and those were to be decided in some part by the lower courts. It seems to me that is opening the door, and stop me if I'm wrong, to argue that before the Supreme Court. There may be one lower court that says, no, this is an official or this is a core action. You know, they might bleed over into each other. And that could create even more caseloads or even more arguments to come up in the future, depending on who we wind up electing and what they decide to do.
Well, thankfully, we want to step back and say there's only been one former president who's ever been subjected to criminal charges. So at least we don't have a run on these, and let's hope that we don't have many in the future. But you're absolutely right that there's a lack of clarity in this opinion in many respects. You wouldn't expect it to cover, all the dot every I and cross every T, given the so many different permutations of cases that can arise. But you are absolutely right that these kinds of prosecutions can be so difficult in part because the guidance given by the Supreme Court is so opaque. And particularly the idea of that some types of official conduct cannot be predicated or cannot be used to show that a president has committed a crime in his private capacity. We see that even now in the New York prosecution, right? Because President Trump has tried to vacate the jury verdict in that case on the ground that some of the official discussions between him and subordinates in the executive branch were used to convict him. And they were. I mean, most importantly, the conversation with Hope Hicks and with the president, partially as a candidate, but also partially when he was in office.
Let's talk about that for just 1 second. As you mentioned, we're already seeing some of the impacts on other cases. Donald Trump trying to get that verdict tossed, the delay in sentencing so that the court can go over this and try to determine what can stay and what has to go. We're not going to hear about that until the fall. Are there other effects that we can anticipate, whether in cases that are ongoing now or in things that may come up in the future? What can we look forward to from this?
Yeah, I mean, famous conversation that arose in Georgia when President Trump asked Secretary of State Brad Raffensperger whether he could just find 7,000 votes or something like that. Obviously, to a large extent, President Trump was acting in his private capacity, trying to find votes for the election. He was accompanied by the head of the RNC, the Republican National Committee. So again, it looks to a large extent that he's acting in a private capacity. But to the extent that, Lindsey Graham was present, to the extent that there was some other subordinate from the Department of Justice who had some contact with Georgia officials, then we have this sort of intermingling of the two categories according to the Supreme Court. And we have to make sure that there's nothing in the indictment that remains that relates to any kind of official conduct that the president had with a member of the either the Justice Department or the executive branch. And it just, from all accounts from observers that I've read and my own reactions, it makes no sense. That it's very common in criminal prosecutions that evidence is used to help form the intent to commit a crime that isn't part of the crime itself. And therefore, you would think that the immunity issue would not be framed in the way framed by the Supreme Court, because, again, it's like hindering the prosecution from showing that a former president had criminal intent in undertaking the acts that he did.
Let's boil it down even more granular. Chief Justice Roberts was writing for the majority. In that writing, he seemed to kind of dismiss the dissenting opinions, especially when Justice Sotomayor wrote, quote, "With fear for our democracy, I dissent." Is that hyperbole?
I think it's partial hyperbole. I mean, I disagree with many who say that there should be no presidential immunity. I do agree with the Chief Justice that there should be a core area in which presidents are criminally immune from suit. But I do agree that the majority opinion in the court drew such a broad brush that is going to make a very small area in which former presidents can be criminally tried. And, I admire that at least Justice Barrett peeled off from the majority on the point that we discussed earlier, saying that she didn't understand why the Chief Justice was saying that the prosecutor couldn't even discuss official matters in trying to prosecute a president acting in his or her private capacity.
Now that the court has kicked this back to a district judge, what's the sequence? What happens from here?
Well, there'll be a hearing relatively soon. There'll be an inspection of the indictment, and both sides will argue about what can stay and what cannot stay in the indictment pursuant to the instructions, such as they are, given by the Supreme Court. And then Judge Hutchinson will have to make a decision and trying to be conservative about how the prosecution go forward. My guess is it will go forward on a shoestring, that there will be parts that have to be pared out, and that Special Counsel Jack Smith will just have enough of material focusing on discussions with, John Eastland or with Rudy Giuliani and other evidence to show that there's enough conspiracy there to overturn the lawful processes of our election. Some aspects of the indictment will probably be thrown out, but I think that there are likely to be some charges remaining. But then, after that is concluded, if my prediction is correct, that will give President Trump another bite of the apple, and then he'll be able to appeal what is left of the indictment to the higher courts. So this is built in for delay after delay, and certainly we're not going to see the end of this before the election.
Harold Krent, Chicago Kent College of Law professor and author of the book Presidential Powers. I want to thank you so much for joining us on Bloomberg Law. Coming up, a ruling on state laws that restrict social media. We're going to tell you about the unanimous Supreme Court ruling still resulted in 5 different opinions from the justices. That's next on Bloomberg Law. I'm Amy Morris, in for June Grasso. This is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
This is a special edition of Bloomberg Law. I'm Amy Morris in Washington. June Grasso is off today. She'll be back next week. And we now turn to a discussion on social media restrictions imposed by states. You may remember on Monday, the Supreme Court made a decision seen as a partial victory for tech companies. In a unanimous 9-0 decision, the High Court declined to say whether Republican-backed laws in Texas and Florida were constitutional. They sent the case back to lower courts for further analysis. Now, while the ruling was unanimous, it still resulted in 5 separate opinions from the justices. To break this all down for us now, we're joined by Rick Garnett, professor of law at Notre Dame and director of the school's program on church, state, and society. Rick, it is a pleasure. Thank you so much for joining us today.
Thank you for having me on.
Let's talk about these laws. What were the laws in question? I know the states, Texas and Florida, wanted to limit somehow how social media sites regulate content. What was the pushback?
Yeah, these are interesting cases. So there are subtle differences between the two laws, but I think for our purposes, the bottom line is pretty clear, is that in each of these states, the legislature back in 2021 enacted laws that would restrict social media companies' content moderation practices. And among other things, would have required these companies to give individual explanations to anybody whose content they removed or blocked or what have you. And it was kind of interesting. The cases are going on parallel tracks, and the 11th Circuit, which serves the southeastern part of the United States, had said, we think this Florida law is probably unconstitutional. And then the Fifth Circuit, which is Texas and Louisiana, said, we think the Texas law probably is constitutional. So neither of them actually reached the ultimate decision, but they reached their probably judgments. And the Supreme Court took the two cases together to give us some guidance on whether those probablys were correct.
Well, let me back up for just a second and help me distinguish how this is different from that new law in New York where they limit the algorithm suggestions for minors. Could that ultimately be challenged as well under the same circumstances?
Oh, it's a great point. I mean, so these cases clearly have implications. So there's two layers to this. To the Supreme Court's decisions about these two laws. One layer is really technical, and it has to do with the difference between what lawyers call facial challenges to laws and as-applied challenges. And that's kind of a fancy way of saying sometimes when you attack a law, you say it's unconstitutional in every conceivable circumstance. And sometimes when you attack a law, you say, well, it's unconstitutional in this particular circumstance. And the reason why the justices sent the cases back was, in their view, neither of these lower courts had done all of the analysis you're supposed to do when you're dealing with a so-called facial challenge. So that's the technical layer. Below that, though, is a big picture question about the freedom of speech in the First Amendment. Namely, are governments allowed to restrict editorial decisions that are made by media institutions in order to try to produce what the government thinks is a more diverse or a better marketplace of ideas? That was the kind of reason that Texas in particular gave for its laws. Like, look, we worry that these tech companies are using their content moderation practices to really push the marketplace of ideas in a direction that we don't like. They're censoring some people on one side of political issues or public health issues or whatever, and we want to make sure that they're not doing that. And a big takeaway from the court is that it appears that a majority of the justices believe that A, social media companies are protected by the First Amendment, B, their editorial decisions count as speech, and C, the government's not allowed to take on for itself the task of making the marketplace of ideas better. So now you can connect that to the New York proposal that you mentioned. Similar principles are going to be in play there. Now, there's a lot of First Amendment law out there about the government's special authority to deal with cases that involve protecting minors and so on. So there'll be some important variations with the New York law, but in terms of general principle, I think we can take that A, B, and C that I gave you as having important implications going forward.
So it did boil down to a free speech issue, but only in part then, because there is that technical part of it that you were explaining.
Yeah, when you're doing it, the justices, I think, were almost a little frustrated. Is that, several of the justices said, if these social media companies and it's these courts had focused much more precisely on the application of the Texas and Florida laws to particular practices, like, say, the curation of a Facebook feed, then we could have analyzed that issue. But the thing is, these companies do all kinds of things. Justice Barrett pointed out, for example, that the First Amendment issues might look very different if you're comparing what Uber does to what TikTok does. And she also made the interesting point that the First Amendment issues might look very different if you're talking about a corporation that's foreign-owned versus one that's domestic, because the First Amendment laws can vary there, too. So basically, the justices' message, and on this point they were unanimous, was that this case is really complicated, and both the Fifth Circuit and the 11th Circuit needed to do some more work in order to focus more specifically on all of the different kinds of practices that social media companies engage in. Where you had some disagreement, and this is what I think will be really interesting to watch, is that some of the justices, three of them, joined an opinion by Justice Thomas, who was, I think, signaling his view that we do need to be concerned about the content moderation practices of social media companies. And he connected this issue to an ancient issue in our law having to do with companies that are so-called common carriers and concerns we might have about these companies misusing their monopoly position in order to act as kind of choke points. So there'll be some interesting debates going forward once these procedural issues get refined a little more.
This is a unanimous decision, yet with 5 separate opinions, because they all agreed to send it back to the lower court, but at the same time, they didn't agree on why?
Yeah, so as you said, they all agree we got to send this back. What they disagreed about was 3 of the justices said, look, the rest of you are saying a lot more than you need to say. You're pre-deciding the issue in a way. Justice Thomas would say that Justice Kagan's opinion, which is the one that had the most votes, it went a long way towards saying the Texas law is going to be unconstitutional even after it comes back to us. And I think Justices Thomas Alito and Gorsuch wanted to be like, no, we're withholding judgment on that because we're still open to the possibility that the First Amendment does permit states to regulate at least some of the content moderation decisions that the social media companies engage in. Whereas I think a majority of the justices were kind of signaling their view that editorial decisions that are made by social media companies are protected speech and that states can't regulate them. And then you have some really kind of fascinating hypotheticals. Justice Barrett raised the issue of, when you have content moderation being done by artificial intelligence programs, or when it's done by virtue of an algorithm that's not coming from the company itself, but an algorithm that is fed by the social media users' own data inputs. So these are going to be hard questions, right? And so this case is not over by a long shot.
Okay, so then where are we going from here? What is this going to mean for social media? My vision is that we're going to go back to the sort of Wild West on the internet. And I don't know that anybody necessarily wants that. What does this allow for?
Yeah, so I'm not an expert, and I'm bad at predictions, the old joke, especially about the future. I mean, what this means in the law context is more litigation focusing on all of the various different kinds of things that different social media companies do, and trying to think through, okay, maybe some of these functions can be regulated and maybe some of them can't. But as you know, this is an area where things are changing so fast. It's difficult. The Supreme Court's always struggled with this at least for my lifetime, because as media technology changes, the ability to adapt First Amendment doctrine is tough, right? So I guess if you ask for a prediction, the issue's not going away, and we will continue to see, I think, commentators and politicians and legislatures expressing concern and perhaps enacting regulation to try to make sure that social media companies aren't discriminating against disfavored views. But at the same time, you'll see the social media companies invoking their First Amendment rights to make the editorial judgments that they see fit, and to be continued.
Indeed. Before we let you go, I want to ask about what the Supreme Court is prepared to handle. And what I mean by that is AI is a whole different world. And you were talking about the implications of if AI was creating the algorithm based on what the user is doing. Is our Supreme Court able to manage the really heavy-duty questions, particularly when it comes to this whole new world of AI and other technologies that we might not even know about yet?
Yeah, it's going to be a challenge because, when you talk about the freedom of speech, it's easy when you think about a person standing on a soapbox in a park making a political speech. We all get that. A pamphleteer, a newspaper, and then we had new technologies, radio, television, and still, you get the basic idea. People are speaking. For a while, there was some debate about whether corporations had free speech rights, but it seems pretty clear that they do because corporations are made up of people and they're vehicle for people's expression. What's going to be interesting with some of the AI stuff, I think, and I don't want to go too far out of my depth, is that it's harder to characterize some of the outputs of these large language models. as actually being attached to any real people. And so then it's hard to see exactly how the First Amendment should apply to expressive decisions that are being made by ones and zeros. And I think they're going to have a tough time figuring out how to deal with that.
That is going to be fascinating to watch. We have no idea how this movie is going to end. Rick Garnett, professor of law at Notre Dame and director of Notre Dame's program on church, state, and society. We want to thank you very much for joining us on Bloomberg Law. Now, coming up, what we did and did not learn from the High Court's latest term. That's next on Bloomberg Law. I'm Amy Morris. In for June Grasso, this is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
This is a special edition of Bloomberg Law. I'm Amy Morris in Washington. June Grasso is off today. She's coming back next week. We now turn to a much broader discussion. The Supreme Court has wrapped up its latest term with rulings on everything from presidential powers to abortion rights and the power of federal agencies. There is a lot to glean from what the justices decided and what they didn't. Let's get the view now from Elizabeth Wasserman, Bloomberg's legal editor for our Supreme Court coverage. Elizabeth, thank you for joining us today.
Oh, it's my pleasure.
Let's start with immunity. There's a lot to unpack here. Give us your take.
Well, Donald Trump had a very good year at the Supreme Court. You know, a couple of months ago, first he won that ruling about the that after he was kicked off the Colorado ballot over the insurrectionist clause. And then, in probably their most substantial ruling this term, the court found that he's substantially immune from prosecution on charges that he tried to subvert the 2020 election. The ruling basically sent it down to a lower court, and that pretty much guarantees that he's not going to face trial on this election interference case before the election.
Now, why is that significant? A lot of people keep saying that. Explain why that matters.
Well, that matters because there are some people who believe that voters should have some kind of court verdict or jury verdict on what happened 4 years ago and whether he did anything wrong. So the American public won't get to hear all the evidence and see a trial. What's going to happen is that, and why this is also important, is because he was seeking to delay the case because if he wins the presidency, he can instruct the Justice Department to dismiss the case. He has that power. And, in fact, the court gave him a lot of power, gave the presidency a lot more power this term. In this ruling, the court basically said that certain acts of a president, official acts, have absolute immunity from criminal prosecution. This is a new power that they gave the president. And what the lower court is going to have to do now is go through that indictment from Special Counsel Jack Smith and figure out which actions were those of a president versus which were those of a private citizen.
So official versus unofficial.
Yes, or president versus candidate for president. And that could be in terms of evidence in his tweets. Were his tweets a presidential record, or were they a person campaigning or a person expressing their views?
So something you said, does this also apply to candidates for president?
No.
Okay.
No.
So that would still be a private citizen.
As a candidate,
then.
He'd be a private citizen.
Okay.
Yes. But that's some of the argument, is that he was doing some of this, and some of this was sponsored by his campaign. That will be a question that the lower court has to answer. Remember, he's accused of a bunch of different actions. Conspiring to promote false claims about election fraud, pressuring the Justice Department to investigate these claims, pushing Vice President Mike Pence to not certify Joe Biden's electors and make Biden's victory official, and also inciting the crowd to storm the Capitol. And the court may have created more work for the lower courts because they gave clarity on some of the actions that would be considered the actions, official acts in this case, in Trump's case. They said, for example, that his efforts to push the Justice Department to investigate and threaten, and he threatened also to replace the Attorney General if he didn't investigate. Those were official conduct, and he's immune from any charges related to those.
You talked a bit about January 6th and what happened that day and Donald Trump's role in it and how the court weighed that. There was also another case about January 6th,
yes.
and that was focusing mostly on obstruction.
Yes.
Bring us up to speed on that. And it seemed almost as though that was foreshadowing this ruling that was going to come about immunity. Did you see them also linked?
Yes, I did, because this case also tangentially relates to the election case against Trump. Mm-hmm. So 2 of the 4 case counts against Trump involve this statute which was at dispute before the court. Mm-hmm. The Justice Department had used this 2002 statute that makes it a crime to obstruct an official proceeding in charging many of the January 6 rioters. I think that it was about 350 of them, including Trump, with this charge. But what the court found in siding with one of the rioters, this man named Joseph Fisher, who's a former Pennsylvania police officer who stormed the Capitol that day, the court found that they took issue with the law, not necessarily the actions. The law was enacted in response to the Enron collapse in an accounting scandal years ago in which physical evidence was destroyed. And in this case, in the January 6th case, the court found that the law can only be used in cases in which it's alleged that documents or other records were destroyed, and not simply in the act of trying to thwart a congressional proceeding.
Okay, so let me boil it down then.
Yes.
They can't be charged with obstruction because they didn't actually obstruct anything. They tried to, but failed, so they're not charged with that. Is that how the Supreme Court says it?
The Supreme Court says there weren't paper documents involved. There weren't records that were involved, although there are some people who say in Trump's case there were records of the electors that were being brought to the Capitol to be certified by Congress.
So, yeah.
So, but that's something for a future court to decide.
Now, let's jump ahead a little bit. That's because there's a lot to unpack there too, but we need to move on. Federal powers, SEC, Chevron. I got a crash course in what Chevron means. And once you boil it down, it's not nearly as complicated as it sounds.
No, and it's not just about a car.
So, it's not just about fuel.
No, it stems from Chevron versus Natural Resources Defense Council, a 1984 ruling that's been used for the past 40 years as a building block for new regulations from federal agencies. And what the court did was they tossed this legal doctrine that had let federal regulators interpret unclear laws for newer problems or for more scientifically specific rules and regulations. But the court decided that they tossed it. It will have a tremendous impact on environmental agencies, consumer, financial regulatory agencies such as the SEC. And the problem with it is that our Congress right now, for the last several years, has been dysfunctional. Mm-hmm. They can't agree, the parties can't agree to pass laws that provide more specific guidance for regulating new areas such as climate change or crypto or AI. And so agencies have been taking older laws and trying to make new rules for these newer areas under under older statutes.
Now, it's looking ahead also, the SEC was also wrapped up in another decision by the Supreme Court, and it sort of took some teeth away from their enforcement power, correct?
It did, yes. So the SEC had been, and also some other federal agencies had been using in-house judges at times. So sometimes they're administrative law judges. So sometimes the cases wouldn't go to court, but if they could get a settlement before an administrative law judge, they would go that route. It was quicker. It was easier for them to handle more cases. They used this to, the SEC used this to take care of about 100 cases per year. More recently, they've avoided using it because they sensed that the Supreme Court was pushing back on some of the federal agencies and their power. And so now what it means is, particularly where it applies to financial damages, defendants have a right to go to court. And that means people or companies have a right to go to court and before a jury to determine if they need to pay financial settlements.
So not using the in-house judges, but actually having a trial jury or a judge, an actual court.
Yes.
There are so many other issues that have come up in this term. I wanted to hit abortion.
Yes. So on abortion, on the surface, it looked like the abortion rights advocates had a good run this year at the court, especially compared with 2 years ago with the Dobbs decision overturning Roe v. Wade. But the two rulings were very technical wins. They almost seemed designed to avoid a controversial ruling in an election year, and they basically just kicked these issues down the road a bit. In one regarding the a widely used abortion pill, that the justices basically ruled that the group bringing the case had a lack of standing. That means it may come back to them. In the second case, the court dismissed a case about Idaho's very strict abortion ban. And the government had challenged, the federal government had challenged it because they felt that their own law on emergency room that requires measures to preserve someone's health if they're brought in. But the Supreme Court's opinion wasn't about the issue. The courts decided that, it had taken this case too soon. It's going to go back to the appellate court.
That wasn't on the merits.
Nope.
That was on the technicality.
Exactly.
All right.
So these were not pure wins for abortion supporters.
All right. We got so much. We really needed a lightning round there.
Okay.
There were so many different issues and so many different cases that came up in this particular session. Is that unusual? Was this a busy one?
No, it wasn't. As a matter of fact, they used to handle 100 cases. This was a rather light year.
They just felt big.
It felt big because everyone had to write a dissent, and the court was very much divided along ideological lines.
Thank you, Elizabeth, for taking the time with us.
My pleasure. Thanks.
Elizabeth Wasserman is Bloomberg legal editor for Supreme Court coverage. Our thanks also to Harold Krent, professor at Chicago Kent College of Law, and Rick Garnett, director of Notre Dame's program on church, state, and society. And that does it for today's edition of Bloomberg Law. I'm Amy Morris, in for June Grasso. For more Bloomberg Law analysis and interviews, you can head to Apple Podcasts, Spotify, and the Bloomberg Business app to download the latest edition of the Bloomberg Law podcast. Stay with us. Your top stories and global business headlines are coming up right now.